Objection. Movies and TV shows make it sound like objections are just yelled in court by anybody after every other sentence, or whenever a lawyer feels like it, or even just for dramatic effect. An objection is practically a courtroom anthem in legal dramas.
Objection.
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 Objection, Your Honor. Objection.
Objection.
Objection, Your Honor! Strangling the witness!
I'm going to allow it.
So, what exactly is an objection? In simple terms, an objection is when a lawyer interrupts the proceeding to challenge how a witness is being questioned or how evidence is being introduced. The lawyer is basically saying, hold on, something is not right. Objections are made to prevent improper, irrelevant, or misleading information from being introduced into the trial. The right to object traces back centuries in English common law, which forms the foundation of legal systems in places like the UK, the US, and other Commonwealth countries. Lawyers use objections to ensure fair trials by challenging any misleading, irrelevant, or overly prejudicial evidence. Over time, these objections became an official tool to help lawyers keep the trial in check, as they could point out what seemed unfair or improper. When a lawyer calls out objection,
Objection, Your Honor.
it's not just a dramatic move, it's a structured legal mechanism aimed at keeping the trial fair. In practice, once a lawyer says objection,
Objection.
the proceedings pause for a moment, and the judge decides whether the objection is valid or not. This is where the two most important words come in. If the judge sustains the objection, it means the judge agrees with the lawyer. The judge's decision to sustain means that whatever the objection was about must be removed or rephrased. However, if the judge overrules the objection, it means, no, I don't agree. The trial will continue as it is. Objections can only be raised at specific stages of the trial. For instance, during witness questioning, objections may be used to challenge questions, statements, or evidence that could mislead the court or violate the rules of evidence. Now, here's where it gets interesting. Every time a judge sustains or overrules an objection, it's officially recorded, and sometimes the judge may overrule an objection where they shouldn't, or sustain one where they shouldn't have. When this happens, the lawyer who raised the objection can use it as a ground for appeal after the case has been decided, essentially allowing the lawyer to contest the ruling and request a review of the decision in a higher court. Some of the reasons an objection is raised are: 1. Relevance. An objection based on relevance is used when a lawyer believes that a piece of information or a question has no bearing on the case. For example, if a lawyer asks a witness about something unrelated to the case, an opposing counsel might object saying, objection, relevance.
Objection. Relevance.
2. Hearsay. Hearsay objections come into play when a statement is made about something the witness didn't directly observe. Essentially, it's second-hand information and is usually not allowed unless it meets certain exceptions.
Objection, hearsay.
3. Leading questions. A leading question is one that suggests the answer, often used during cross-examination. Lawyers object to leading questions to prevent witnesses from being influenced by how the question is being phrased. 4. Speculation. This objection is used to prevent witnesses from guessing or making assumptions rather than providing facts that they directly observed. 5. Misleading questions. If a lawyer tries to confuse or trick a witness with their line of questioning, the other lawyer can object. There is also an objection called a preliminary objection. Unlike objections raised during witness testimony, preliminary objections are raised before the trial even starts. This objection focuses on procedural issues, such as jurisdiction or whether there is enough legal basis for the case to proceed. It's a way to potentially stop a case before it even gets off the ground. So, The next time you hear objection in a legal drama,
Objection.
remember, real courtroom objections are a lot more about upholding the law and keeping the trial fair, not about drama or shouting matches. And if your objection gets overruled, well, you can't fight it in the courtroom right away, but you might have a strong case on appeal later. Thank you for watching. If you have more questions about the law or courtroom procedures, hit that subscribe button and don't forget to tap on the notification bell.